Let me start the recording here and I'm going to begin sharing my screen. So just looking for some confirmation that folks can see what I've got going on there. Beautiful. Love your thumbs. Thank you for joining us today. If you're live here at the session or if you're watching this back in the recording or maybe both, thank you for coming back. Thank you for joining us. I'm Veronica Howard. I'm a faculty member in the Applied Behavior Analysis and Autism Studies program, and I love copyright. So I'm excited to be able to present this as part of an ongoing dialogue and discourse related to our policies, our rights as content creators, and to make sure that we as a general university are more informed about our rights as creators. So for our session today, I have a few goals that I want to make sure that we cover. I'm just going to lay these out very quickly and we're going to dive in deeply to honor everyone's time. Following this session, I hope that you will be able to identify and maybe articulate some of the core intellectual property or IP philosophies. These are philosophies that have been written about for hundreds of years. So these conversations that we're having now are just a continuation of a rich discourse that's been happening for ever, really. Next, we're going to be talking a little bit about copyright. Oh, just one moment. Let me go ahead and in security, I'm going to disable the waiting room so anyone can get it. In this session, we're also going to be talking about the distinction between different kinds of copyright laws and paradigms. Specifically, I'm going to help compare and contrast for you a traditional or all rights reserved copyright versus some open licenses. We are very extensively going to be covering the Mary Baldwin University copyright policy, which has been previously discussed. So check out the resource guide if you haven't already seen it, or make sure that you're linking to it from the resource guide today to really get into that content and better understand it. And then next and finally, I'm going to give some practical suggestions for how a person might share their course content with others while exercising varying levels of control over access and reuse of those materials. But like I said, this is some controversial content. So I want to start with a little bit of a disclaimer. First of all, I am going to be speaking primarily to an audience of faculty members. And you'll note that the Mary Baldwin University policy is intended for all users. We'll talk about that in a moment. However, I'm going to focus almost entirely on issues related to faculty content creation, particularly content creation in the context of delivering a course. Next, it's very important to note that though I love copyright, I am not a copyright lawyer. And more importantly, I'm not your lawyer. So if you have questions or if you have concerns about this content, it would be really helpful to engage either with a copyright lawyer or, if you have grievances and concerns, a labor lawyer to discuss and understand what your rights are as a content creator. Next, I haven't seen your employment contract, so I can't give you advice. I would encourage you to review your employment contract very carefully and to discuss your employment contract with the university before you sign it so you understand what your rights are. Next, I'm not your supervisor. So please don't walk away from this session believing that I've somehow given anyone permission to do a particular thing. This is meant to be, like I said, discourse. I want to share information. I want to share my perspective so that it might create an opportunity for additional clarification, additional conversations, so that you as a content creator can better protect yourself and your creations. And your participation is very, very welcome. I'm going to try to prompt you or warn you in advance that an opportunity for discussion is coming using this on-screen note. So let's begin. What is copyright and what is copyrightable? Note that I do have a prompt on screen. That means discussion is coming. When we talk about copyright, we're referring to a class of laws that are meant to protect intellectual property. They're meant to safeguard the rights of the creator or the rights holder of that intellectual property for the use and reproduction of creative works. Now, this all sounds really dry, right? Really abstract, really arcane. Who really talks about copyright? Why are we even talking about this here? In modern culture, it does exist. So no spoilers, but if you've seen the movie Glass Onion, like the Knives Out Glass Onion Netflix film, the core issue there, I mean, aside from all the murder, is issues related to intellectual property. Who owns intellectual property? No spoilers. Does anyone here enjoy music? Okay, wonderful. We have people who enjoy music in our audience today. You may or may not be aware that a incredibly influential artist, Taylor Swift, recently had some copyright issues related to her back catalog. Who controls the recordings? Who controls the composition? In 2023, there was a big kerfuffle between Taylor Swift and her label. Who is going to control access to those? And at some point, Taylor Swift walked away from that label and as a result had to leave her IP with that previous recording artist. That's why we've seen a reintroduction of those works, what are called Taylor's versions. Please do not ask me to elaborate on this. I am both not a lawyer and I'm going to be very brave here. I'm not a Swiftie, so please don't come for me in the comments. But we see that copyright is relevant. Copyright is, though it seems kind of dry and dusty, it is at the heart of what we do. These rights are meant to protect people. They were meant to protect Taylor Swift and her entire catalog. But we find that there are a number of ways in which copyright is applied or misapplied or not understood. And as a result, we might not be using it to its best effects. There are some key considerations here in copyright. So first, note that copyright applies to the creator of the content or the rights holder. And that's the core issue in that Swift back catalog situation where Taylor Swift was the creator of that content, but the record label controlled the rights to those IP. That's why Taylor Swift re-recorded all of those articles, or articles. That's the scientist in me, all of those songs. And it's worth noting that not all content creators are rights holders. This is where we get the clause work for hire, when a person is hired to create intellectual or copyrightable property, but they're not expected or afforded the rights over the reuse of their material. The next consideration, the next feature, is this idea that copyright applies to anything that's in a fixed medium. This used to be, you write it down, you mail it to yourself, so you have evidence of when you created it. You got that post stamp and everything. Now, if you put it in a cloud document, so long as it's written down somewhere, it's tangible in some way, that is a copyrightable piece of intellectual property, as opposed to really good ideas. If really good ideas are never really written down, then they're not copyrightable. Next, copyright applies to creative works. So it does not apply to ideas. Like I said above, if it's not in a fixed medium, it's not copyrightable. It does not apply to facts or processes or systems. Some of those might be better protected by patents, especially processes. But have you ever gone online to like find a recipe for guacamole or soup? And to get to the recipe, you have to scroll through like 45 pages of how this person went to a little taqueria in Baja, and this is how they made their guacamole, and it was such a life-changing trip. The guacamole recipe is a process. It is not copyrightable. But that story of the trip to Baja, the taqueria, the life-changing whatever, all of that is the creative work that is copyrightable. That is part of the reason that people include a lot of that like fluff content in addition to other commercial considerations. And then last here, these copyrights apply to the use or reproduction of that work. And so when we're talking about these different rights and use considerations, we're talking about the ability to retain a copy, to reuse that material, to revise or refine the material, to remix the material, and to redistribute it. When we talk about open licenses, these are the 5 R's related to content creation and reuse. So these are the kinds of activities that we're talking about. I did promise that there would be an opportunity for discussion, and here it comes. From your perspective, why copyright? Like, what's the purpose? Why do we have these legal rights and protections? Who are they meant to benefit? If you're watching this recording back, you may want to pause here to give it some thought, but I'm very eager to hear what you have to say.
I think it's, at least for me, it's meant to protect or benefit the creator, that their creative thoughts, ideas that are written down, as you say, are protected and no one else can claim them.
Absolutely. So we're talking about measures of protection, and like protecting what though?
Someone's ideas, thoughts, I mean, that's their intellect, to protect their intellectual property. Their,
No,
what they created, right?
this is not easy, right? Like when we say that it's meant to protect, are we talking about it's meant to protect the integrity, the message, the meaning of the creation? Is it meant to protect the to prevent unauthorized access or reproduction, like to give control to the creator to let them decide how they want their content to be reused? Is it is it fiduciary? Like, is it about money?
Yeah.
That's what Rachel asks. Rachel says one reason could be financial. Oh, we're there. Could be financial to benefit the creator. And then Ryan Sane says, well, I agree with Rachel. Oh, all these emojis.
Yeah.
I often find myself lost in the story completely until my 10-year-old yells from the other room, is it ready yet? No, honey, it's not, LOL.
No, we haven't made the guacamole because we have to hear the life-changing trip to Baja.
And then Stephanie Siebold says protecting someone's own creativity and ideas. Chandra Mason says control is the main thing for me. And Rachel Potter weighs in again. Yes, also to protect integrity. If it changes, not fully attributable to the creator and their original thought.
Yeah. And these are all right? These are all correct. And they're all deeply connected to these, as I mentioned before, these prevailing core philosophical theories of intellectual property. So I want to go through those just pretty quickly to give you an overview. If you're interested in this, right, don't forget that I've got additional speaker notes in the slides, which are linked in the resource guide. In the resource guide, I'm going to pop it back in a chat one more time, just in case you came in a little bit later. I also have some links to recorded lectures from a proper intellectual copyright lawyer at Harvard University. And I find the lecture material to be exceptional. I enjoy watching it, and I enjoy being able to reconnect with that material to share it with you today. So if you love this kind of dry, dusty, amazing content, hop in there. You're going to love those lectures. The first theory that we sort of talked about is this idea of fairness. It's about protecting the author. There's a deep connection to the idea that that the intellectual property is a product created from the labor and creativity of the author, and that they should be compensated in some way. They should be rewarded. We should incentivize the creation. And the way that we incentivize that creation is, that they reap what they've sown. They benefit from that creation. There's an extended kind of exploration of this idea that when we create, whether it be a tangible good or an intellectual ephemeral good like ideas, or the fixed medium of our creation, that the ownership of that good should follow the most valuable component of its production. And I would argue, for instance, when I create a lecture, that the lecture that I create is generated based on multiple years of experience, an extensive education, which was very expensive to me, additional time and effort in creating those materials, the raw materials that I have to contribute to the creation of it, the time, which I think I've mentioned, but is always scarce and we should consider. And so it could not have been created without all of those factors. And that ownership would follow the most valuable portion of the content creation. There's also tying to like a deeper moral philosophy of John Locke, that in this idea of fairness, we're talking about the idea that the owner or the creator of that content should have the right to preservation, meaning that we shouldn't simply be taking things from people if it leaves them in a position where they can't meet their basic needs for housing and food, where we deprive them of security without their content anymore, right? So when we talk about fairness, this one comes up a lot. We're going to discuss these in some scenarios soon. The next theory is personality. And I'm hearing a lot of folks speak to issues related to connection, fidelity, having control and exercising control over what, where, and how their work is presented. This personality theory simply is a class that refers to this idea that the creator should be entitled to exercise control over their materials. There's this wonderful letter from the creator, the artist who makes the Far Side cartoons, that at first he did not want his cartoons on the internet. He didn't want them shared very widely because they meant so much to him, that they were like his children. And wouldn't you want to know if your children were out somewhere on the internet unaccounted for at 3 a.m? It's a pretty extreme example, but it also ties very closely to this idea of personhood theory, which is that the content that we create is an extension of us. And when you harm that content, you harm the creator of that content. And when you deprive the creator of autonomy and control of their content, you deprive them of a part of their identity. Now, you'll note that these two theories are very individualistic in nature. They're very, very focused on the content creator and the rights of the individual who created that content. The next two theories that we're going to discuss, which I'll pop up here, tend to be a bit more collectivist. There are also philosophies related to intellectual property and copyright that say that, like the welfare theory, intellectual property is a public good. It has the potential to benefit many. And proponents of the welfare theory would say that we should incentivize content creation, but then we should also use our copyright laws to encourage and mechanize widespread distribution. There was a move during the Obama administration that any material that was created using federal grant funds would have to be openly licensed or open access. And we see this aligns very well with the welfare theory because the goal there is to benefit the many. There's no reason, according to that administration, that we should be using federal tax dollars for materials that then get locked behind paywalls and then you have to pay for them to get them and so forth. The last culture is quite a bit more abstract. It's the idea that copyright law should be written and implemented in such a way that it encourages and incentivizes, induces content creators to exercise their rights in a way that benefits the most good, that contributes to what we would call a just and attractive culture. And the idea of the cultural theory of copyright law is that everyone should be entitled in a culture to a fair share of the intellectual property. This is all about distributive and redistributive justice. It means that if you're in our culture, you should benefit from the fruits of our culture. Now, you can see a lot of the things that we talked about are reflected in these core philosophies. That idea of not taking a person's work out of context, that idea of having control, that idea of being compensated fairly for your work. Those are some things that we've talked about. But also, welfare and culture, they're kind of collectivist and emerging theories, are things that are not talked about as much, but are, I think, important to consider. Especially, this is philosophy, when we talk about practice. There's a difference between philosophy and policy. We're going to be talking pretty extensively and applying the MBU intellectual property policy. Note that this policy applies to everyone affiliated with Mary Baldwin University. This is our faculty, our staff, our students, independent contractors, consultants, anyone who's paid by Mary Baldwin, this policy applies to. If you are not familiar with this policy already, go ahead and check out the resource guide. There's a link to it. I would encourage you to read it, to ask questions about it, to discuss it with people, because it's important to consider. I want to highlight a few important details specifically as they relate to the work and intellectual property of faculty. The policy reads, and I'm going to paraphrase this lightly, that the covered creator of copyrightable intellectual property shall retain their rights, and the university will not assert ownership rights in the work unless, and then there are a number of provisions. Now, this is found on page 3. There are a few exceptions to this. So first, This idea that if a material is funded or developed by sponsored research or some third party agreement. In this particular case, what that would mean is, for instance, like I mentioned previously, working on a grant at another university, if you create material that is funded by like the government or funded by the state or funded by a private institution like a healthcare organization, either the university and or the healthcare organization are going to retain that copyright. And typically those are some conversations about ownership and authorship that are going to be had outside of the control of whoever's doing the creation. This is probably why that provision is in there. So we would expect that this is probably a work for hire situation here. This is why it's important to have some of these conversations about ownership and who's entitled to what and how can you reuse it prior to creating content. These are the same rules that I use when I'm working with students or when I'm working with co-authors. So there's no confusion. Another exception here is if the content creator, and remember I'm talking about faculty, was assigned, directed, or specifically funded to develop the material. So I'd like to draw your attention back to the quoted text on the left. The university will not assert ownership rights in the work unless a written agreement with the covered creator provides otherwise. This is that clause. So if your contract, which I have not seen, please recall, indicates that you are receiving credit or you're being paid as part of your work to develop a course, then it might be worth having conversations about what does that mean? Does that mean that my time is being spent this way? What about the materials that I'm using in this course? What does it cover? What does it not? To leave any doubt would suggest that anything that's created for that course could be conceived of as a work for hire if it appears on your workload. Let me go ahead and move on to the third one. Oh, excuse me, I've gone too far. Third, this one, it kind of gets into co-authorship territory. If the creation of the content required the substantial use of university resources that's above and beyond or in excess of the resources that are typically available to other content creators at your university. This could be, for instance, funds, especially if those funds are used to pay for your time, like an overload, to pay for access to software. Could be facilities, like if the creation of those materials required software, the use of labs or wet labs or creativity labs. If the creation, capture, editing, publishing required the use of staff time to edit and produce those materials, or if there was special equipment that went into creating those. See again, like wet labs, cameras, your work laptop, things of that sort. So it would have to be above and beyond and in excess of the other resources that are typically available here. Under these circumstances, that kind of goes back to that issue of ownership following the most important resources that went into it. Under clause 3, under exception 3 here, it would sort of suggest that you and the university are now in a co-authoring position where you're contributing your time and labor and intellectual property, and they're contributing resources, facilities, funds, staff, equipment. And then those are different conversations to have a priori in advance and get in writing about the use, reuse, authorship, ownership, things of that sort. And then last, was this material developed in the course of employment by a non-faculty university employee? This clause in the exemptions seems to very clearly delineate the difference between faculty members and non-faculty members. It paints the picture that non-faculty members are employees. Their work is a work for hire. Anything that's created that's patentable or copyrightable was a work for hire. This is an especially important consideration to make, to have a conversation about if you are in one of these positions and being asked to create content, particularly if that is beyond the scope of your typical time and assigned duties in your job. I'm going to move on from that because there's an important proviso in our copyright policy. That is, the covered content creator, though you keep your ownership, you keep your intellectual property rights, you own that. You still, however, will be required to grant a non-exclusive, royalty-free, perpetual license to the university for the use of your IP. So what that means is it's your content, you own it, you can redistribute it, you can keep it forever, but you have to let the university use your resource as it's been created. Now, note that I've said you have to let the university use your resource as it's been created. It does not speak to the issue of derivative works. A derivative work is when you transform or change original content to make something new. Derivatives can be as simple as cropping an image. Now it's a new image, it's a different image, to taking passages and putting it into another format, to taking your name off something. All of those are examples of derivations of the original work, none of which are covered in this proviso. So that's an important consideration if you're going to plan to reuse somebody else's intellectual property. We'll come back to some things you can do to safeguard that in a moment. But I want to warn you, I want to prepare you. I'm going to give you a couple of scenarios that I hope that you'll discuss with me. Let's talk about the first one. Scenario number one, Jeffrey is an IT call center employee, and they've contributed a large number of really high quality training guides to the official university IT knowledge base. Like a knowledge base is like a wiki or a guide, like what you see on screen there, that helps people answer questions like, how do I upload this to Canvas? They've contributed a lot of content into this guide. What would happen if Jeffrey left the university? What happens to the content? Who owns it? Can Jeffrey take that content, take those training materials with them? Now, if you're watching this online, you might pause here to think about your answer. And for those of us who are joining us live, you don't have to have the right answer right away. You could just ask some questions that you might want to know the answer to before you offer an opinion. But let's discuss. Ooh, MBU could continue to use it, falls under work for hire. Okay, so now we're starting to get into questions like which ones are the works for hire? To know if it's a work for hire, we might have to ask questions like, what kind of employee is Jeffrey? Right? If Jeffrey is a faculty member, and there's not one of those four exceptions that we previously discussed, grant funding, exceptional use of resources, assigned to create it, or being a non-faculty member. If we don't meet one of those exceptions, then the IP stays with the creator. But MBU could continue to use it, falls under work for hire. If Jeffrey is a non-faculty employee, I would agree. Yeah, this content was created as a work for hire situation. I might ask some additional questions like, how did the content get into the knowledge base? If Jeffrey created the content on working time and uploaded the content into the knowledge base of his own volition, that makes it really, it starts to stack up a pattern that suggests that Jeffrey clearly understood that this would become part of the MBU knowledge base. There's no effort here to sort of protect or provise those contributions. Jeffrey is a non-faculty employee, which would suggest that their work is a work for hire. What about the second question? Can Jeffrey take their work with them when they go? Who owns Jeffrey's work?
College owns it if it's because Jeffrey is not a faculty.
So to repeat that, Jeffrey is not a faculty member. If this is a work for hire, then that means the rights holder is the university, which means the university controls the IP. Could Jeffrey take the content with them when they go? That's really a conversation to be had. Jeffrey should probably expect that the university is going to say, no, I'm sorry, that's our IP. But then we start getting into this idea of asking permission for reuse, requesting permission, redistributing, things like that. Jeffrey should not assume that anything that they've created during their time and tenure at Mary Baldwin is free for them to reuse in other places. although I imagine that there are some considerations to be made. For instance, what are the general cultural mores of IT work? There could be that there are some guild specific considerations about like what and how content is reused. For example, I see we've got, our associate dean for the School of Education. Educators, teachers tend to be much more generous with their resources and resharing and regifting than, say, some other professions. And you might find that different professions approach these issues differently. That's not a reason to not get explicit permission, though. So I would encourage you when we come back to it to start talking about some of those things. Let's try another scenario. Mette has been hired into the adjunct pool to teach sections of University Skills 101. During her time as an adjunct, Mette develops tons of new course materials in her course shell, but then Mette is laid off. Knowing that Mette has a lot of really high quality course materials, the department chair copies her course shells and redistributes these materials to the faculty remaining in the program. Who owns Mette's course materials? Who has rights to copy and reuse them? And can those materials be edited? Again, if you're watching this in the recorded version, you may want to pause here for a moment, but I'm going to mute for a moment and let my colleagues think about this. How are you feeling? What are some questions you may want to ask? Nice. In the chat, what was the language in the contract? So that goes back to one of the Mary Baldwin policy exceptions. Is there something in the contract that indicates that Mette would be hired to teach the courses and also would be credited like workload time for the development of course resources? That would be something that I would ask, because if Mette was paid specifically to develop course materials, it might mean that this was a work for hire situation. The next question, what was Mette told at the time of hire? This one is a little tougher because, verbal contracts, though important, you have to be able to prove it. You have to be able to demonstrate it. Mette would, of course, be in this position where if they had a verbal contract that her content was her content, and then some less scrupulous new person comes in and says, well, this is our policy, I'm just going to take and use this, and they were unfamiliar with that conversation, that they didn't know that it had happened, then it becomes an issue of like they said. It requires Mette to engage some services, write some letters, maybe get a lawyer. In the chat, in the past, MBU has expected adjuncts to produce content as part of their contract. It would be interesting. I would want to see, if I were an adjunct faculty member, what is the specific language there? And I would want to have a conversation before I signed that contract about what does that mean? Whose property is this? Is it mine? Because even though I'm an adjunct faculty, it seems as if there's no class of adjunct in our policy, so it would appear as if they may be covered as a faculty employee. Which rights apply here? And this one, work for hire, does Mette teach and develop? Exactly. Going back to that issue of look at your contract. What does your contract say? Content creation should not fall under an other works as specified situation, simply because it makes a big difference whether Mette is teaching this course with like, here's a homework system that I plugged into Canvas and I'm going to spend my time, my paid time, troubleshooting student issues, versus I'm going to develop these materials extensively, spending well over the base amount of allotted time expected for my work. Those are very different creation paradigms. And I would want us to be mindful of that when we're talking about this content creation. However, in this particular case, who has the right to copy and reuse them? Well, going back to the proviso in our Mary Baldwin policy, when this content is created by an employee, Mary Baldwin has the right, the creator is required to grant a non-exclusive, royalty-free perpetual license to the university to use these materials in their teaching, service, and educational mission. It's worth noting that grant is an active verb, and I'll be talking about that in a moment, but to reuse the materials precisely as they've been created seems to fall under that proviso of granting the license to Mary Baldwin for reuse. However, you have to reuse the materials as they've been created, as they've been found. Editing those materials in any way creates a derivative material, which is not covered by Mary Baldwin University policy. So if you are going to reuse or redistribute material created by somebody else without their knowledge, and somebody else edits and changes those materials and does commercial or fiduciary harm to the creator, that could mean that whoever contributes to the unauthorized reproduction of those materials is complicit in law breaking. So I would be very careful, and I would spend a little time educating myself about what these different copyright provisions mean. I think that these are important conversations for us to be having, because we are living, like, our policy was written in 2006. It was written almost 20 years ago in a completely different landscape. We see now that the world we live in 2024, at the time of this recording, is very different. We've got people's likenesses being reproduced digitally for use in films. If you've seen like any of the Star Wars films, if you see Carrie Fisher in her likeness being reproduced after she's passed, we see the rise of artificial intelligence that has gotten so good that you can barely detect a difference between what was created by a person with knowledge and expertise versus what was scraped together from potentially unauthorized sources, potentially without the knowledge of the creator. We are entering into a new reality, and in some ways, sort of a grim reality. For example, there are an increasing number of stories about how course materials being used that was created by course instructors that have passed on. And just like reusing a person's likeness or image once they've departed, I start having some questions about that. Like, who is benefiting there? Does the estate of the instructor, of the professor, of the content creator benefit in any way? Does this contribute to the lives and livelihood of those that the instructor would have wanted to benefit? And this one is near and dear to my heart because at the former institution where I taught, we lost just an impeccable researcher, Alan Boris, who was a preeminent international archaeological scholar on Alaska Native cultures, died after a long fight with cancer in late 2019. Alan Boris had extensive, beautiful, well-created course materials. His lecture videos were just fantastic. When my son took Dr. Boris's course in 2021, those materials were being reused. It took a couple weeks before my son, who's, got a parent educator, realized, oh, the person whose name appears on the course schedule is not the TA. It's the new instructor that's assigned to teach this course. For months, students didn't realize that their course instructor wasn't Alan Boris, because I know the colleague who taught this course, who was given this course prep by the university, and he received multiple emails addressed to Dr. Boris. So it starts raising questions about your rights. When does your term as an instructor end? Do you want your term to end? And this is the point when I'm going to switch into how can I leverage my knowledge about people, psychology, and human behavior to kind of shift the perspective on how I protect and use my own content and share it with others. So shameless plug for behavior analysis. I'm a behaviorist. I love behavioral economic principles. I love understanding why people do what they do. I also love copyright law. And I think that the topic that really comes to bear here is this idea of response effort. Response effort refers to the amount of time, the distance, the work, the force, the pressure, the number of things that you have to do to get a thing done. Do y'all remember when we moved to multi-factor authentication? And so then like to log into your email, you had to put in your password, and then you got to get your phone out and you got to wait for the thing to come up, and you got to authorize, and you got to let it see your face, and then you got to go back and you got to put in the. Do you remember those feelings of like, this is such a pain in my tuchus? That is a change in response effort. That is this kind of ratio strain that, oh, is this even really worth it? That comes from changing the response requirement for a behavior. And we know from the literature that response effort is inversely related to the value of a reward. So if you keep the value of a reward or an outcome constant, you increase the response requirement, the value of the reward suddenly decreases. If you decrease the response requirement, the value of the reward suddenly increases. Now, you can use that information when you understand that making a task easier increases the probability that it will occur, and making a task harder decreases the responsibility that it will occur. I'm going to kind of conceptualize this on a spectrum from this idea of like easy to effortful, or perhaps least secure to most secure. And I'm going to conceptualize this in the example of Mette as the course instructor, assuming Mette didn't have a work for hire situation, assuming Mette was brought in as an adjunct to teach courses, right, and not create course content. I'm going to describe some things that Mette might have done differently to exercise additional control over her course content. But I recognize that I'm going to suggest some things that are maybe a little controversial, so I know your mileage may vary. If it starts feeling like very tin hat, very like, oh, this is a lot of effort, Veronica, don't go in that direction, right? Do what makes the most sense for you, for your security, for your feeling good that you're protecting your own content. Do what feels right, but just recognize that you have options available, which is something I wish Mette would have known. Let's talk about content in your course shell. So if it's written materials like instructions or things that you've created, right? You could make sure to download or backup or export your course shell after each class, making sure that all of those assignment instructions and course materials that you've created are in your control. So you could potentially reuse your course content in other places at other times if you go to another university, for instance. If you really wanted to like tighten it down really hard, I guess you could delete your content. Some caveats: only your content. So if you delete your course material from Canvas, you have to make sure that it's only your course material and not your students' content, because that's their IP. And also the university needs to have those records in case there's an appeal for capricious grading, and to make sure that we actually have the ability to assess student learning outcomes. And bear in mind that if you choose that you want to go in a direction where you lock up your content, that the ability to edit Canvas is closed a short period after the term ends or the semester ends. So bear that in mind. You might get better mileage out of simply hosting your content elsewhere. Like host your content in a Microsoft 365 or a Google Drive affiliated with your university email address. Now you have two things that a person would have to copy in order to make the thing work. Your content, you can control access through your storage, and you can control access through Canvas. And if one of them breaks, then now you can no longer use it. This increases the response requirement, may decrease the probability that a person wants to mess around with recreating your course content. If you really wanted to tighten on that tin hat just real tight, you could make copies of, redistribute, back up your material in an external or brand account that's outside of the university, bearing in mind, just like you're linking to stuff in Canvas from you're going to link to that content in Canvas, even though the content is controlled outside of the university. I just cannot stress this enough. You cannot back up student information outside of Mary Baldwin platforms. This is a FERPA issue. This is a privacy issue. This is a student IP issue. So don't do that. Let me show you what this might look like. In my courses, the way that I design my courses, in my assignments, I always link out to assignment instructions from the actual assignment in Canvas. I do this because one, I have a really hard time editing in Canvas as there's so many clicks, it hurts, it's problematic for me. But also because, like I said, you can control access on the other side. So if for whatever reason, if I had reason to believe that a link to my content had sort of gotten out into the wild somewhere where I didn't want it to be, I can adjust who has access to that link. I can tighten it into Mary Baldwin, or I could say just me, right? So these are some ways that I can help control that content operating within the Mary Baldwin space. I could also, like I've done here, use an external account to engage and create course content. So recently there was a very controversial article that dropped in our field, and I spent a lot of time over the weekend, um, let's say, annotating this document using a platform called Hypothesis. I wanted my comments to be public and available to anyone within the field, but I source this material and I link it within my course shell so my students have access to this educational material. This is an example of some of your course materials being outside the university. I do this because it was my own time, my own resources, and it's something that I would want to have access to in other domains as well. It was not on university time, it used no university resources. Does that make sense? I want to pause here for just a moment to make sure that I'm being clear. Okay. I'm going to move kind of quickly through the next considerations because the same is true for multimedia content. Everything that I just mentioned a moment ago is true for multimedia, like images, videos, recorded audio. You can, if you have them in Canvas, you can back them up at the end of each term or semester. Remember, if you have any information that is like an appendix or a resource that goes with that, captions are a really good example. Make sure to back those up too, just to make sure that you have access to those resources. You could potentially host them in a university email address affiliated account, like on Flickr or YouTube or Vimeo or SoundCloud. Potentially a person could kind of recreate access and put those back together, but it gives you more control over how they are connected. Or like with before, you could create a brand channel to reproduce that content and host it externally so you make sure that you don't lose control of it. An example of that, for instance, is most of my lectures are hosted on YouTube. I like YouTube. It's very intuitive for me. I have the ability to control the visibility of those videos. I can make them public so anyone can search YouTube and find them. I can make them unlisted so anyone with the link can use them. But if you don't have the link, you can't just search in the search bar for them. Or I can just lock them down so they're completely private. The other thing that I really like about YouTube is that I can also change restrictions on them, meaning that I set a lot of my videos to be for kids because it changes the kinds of advertisements and discourages or completely omits the ability to comment on videos. This has been really helpful because occasionally, when I don't have the for kids restriction, around election cycles, students report that they get a lot of election ads, and I don't want to expose them to that just because I want to host my material externally. If you want to take a step further, I want to shout out my colleague who does just a really creative way of backing up content, making sure that people benefit from it in other ways. My colleague Ryan and his colleague Brad, they've been working together for years and years and years and years. And Ryan shared with me recently that when he creates a lecture for class, if it's a really good lecture, if there's like a little tidbit in it that's really thoughtful or thinks that it's something that will help other students, he will then go to his own computer, recreate that video, like with his own materials, his own software, his own whatever, and upload that video to this brand channel where everyone can get access to those materials. Bearing in mind, this doesn't use university resources. This is not on university time. This is not depriving anyone at the university of use of those materials. It's just helping to protect access to those materials. The last bit of our educational material is really hard to address, and that is like the assessments and stuff that you have in Canvas. And I am especially challenged by this as a person who has over 2,000 questions in one class in a lot of practice pools, and I've written every one of those questions. It's really hard to insulate your questions and your assessments if you've created them. So you could, at the end of every term or semester, back up those question pools so that you could use them in other places. You could try setting up Canvas so that your quizzes link to pools. And then if for whatever reason you wanted to exercise some control and prevent unauthorized reuse, you could break the connection between the quiz front face, like the graphical interface for students, and the pool that it connects with, if you really wanted to do that. Or, I mean, the last one is really difficult. If you don't want people to reuse your materials, you might have to change those materials really dramatically. Like, it would be much easier to reproduce a 50-item multiple choice test in Canvas, just copy, paste, than it would be to reproduce an extensive essay and reflection series, right? And many people wouldn't want to do that because the effort involved is so much different. But when you're thinking about making those changes, remember that it's not just you, it's the students. So maybe you want to try hosting your question pools and assessments in an alternative open source learning management platform. Is that going to hurt your students? Like, if you force them to go to a site or a platform like Moodle, is it going to create privacy issues, access issues, their time, their attention? Is it going to benefit you but disadvantage them? Can you protect the privacy of their information? This is the most difficult kind of issue to address here. And I want to pause here because there's a wonderful question in chat. Use of substantial university resources an exception for ownership. Is the opposite true? Is not using any university resources to create material offering greater protection? That is a wonderful question for a copyright lawyer. But I will say that when I create these materials and I host them in such a way that I have greater control over them, I will definitely create course content in my own time, using my own computer, on my own platforms, like with video creation software, video hosting software that's not affiliated with the university. And I would not be able to hazard a guess as to whether or not the university would press their right to use it. But I will say, in order to do so, you have to know that it exists. So that's a lot. We've talked about a lot, right? I've told you what you could do. I'm going to suggest some things we should be doing. And I'm going to try to go through these kind of quickly because I'm mindful of the time and not everybody loves this content the same way I do. First, and most importantly, honor the IP rights of others, right? Do unto others as you would have done unto you. And I see a lot of examples of this, specifically like seek and document permission to reuse other people's content. I do this often. I describe for people, hey, can I use this material? I'd like to use it in this way. I'd like to share it in this way. Could I do that? And if a person doesn't respond to me, that tells me no. If a person responds and says, oh, I don't really want you to use it this way, then it's a conversation. But this is all about give and take. This is about conversation. This is about transparency. The next thing is make sure that you operate under that golden rule. Credit people for their work. And this includes both for ideas and artifacts. How many of you have attended a presentation in the last 3 months that had images with no credit as to where the image came from? Or ideas like Steele said this, but no citation as to who is Steele? How do I find that information? Credit people. Give credit where credit is due. Cite your sources. Link to resources rather than reproducing them. Ideally, linking to Grafton University Library resources when you can, because even though you may have the right to download and reproduce and upload them into Canvas, doesn't mean that you should. Just because you can doesn't mean you should. And then finally, educate yourselves. Educate yourself on what is fair use. What are the 4 fair use exemptions to copyright law? What's the 4-factor model? What's the TEACH Act? And how does that relate to online courses and in-person courses? What are open licenses? I'm going to talk more about open licenses in a moment. Next, communicate. I want to highlight, Dr. Bailey mentioned, communicate. your authorship rights and expectations. You'll notice that I've done that here, but making sure that you include that information makes it either easier for others to cite you and to contact you to ask for that permission. It also helps avoid any confusion over your expectations and what rights you're affording to others, how they can reuse that material. This can also help contribute to a larger culture of honoring IP and promoting accountability when violations occur. So if you see something, say something. Don't, I was going to say, don't be afraid to call people out. Obviously, there are circumstances, but there are people who are interested who will call people out. So maybe have a conversation about it. And teach your students to do the same. If you're teaching writing, if you're teaching content generation to students, include this as a portion of the assignment. I've linked to a lot of resources in the resource guide that could be helpful for this, so maybe check those out and maybe consider this to be part of your rubric, having students indicate their usage rights. Now, I don't unfortunately have time to take you through all of the difference and variations between traditional all rights reserved and Creative Commons licenses, which I tend to use, but just bear in mind that traditional copyright is something that's baked in from creation. Since 1974, or possibly 1976, forgive me, when you create something, copyright, all rights reserved copyright is assumed. Quick show of hands, how many of you knew that? That if you find something on the internet, that you can't simply reuse it because it's freely available? Got a couple of yeses, which is wonderful. But they don't teach us that. They don't teach people that. So educate yourself on some of the differences. And if you want some help learning these differences, we hope that you'll come back in a month because Dr. Brency Patino and myself are going to be talking about open educational licenses and the Viva grant, the Viva course creation grant, if you want to get involved in the creation of course content that is openly licensed. Let me wrap it up, right? Because I know this has been a lot. I just want you to know that as a faculty member, unless there's one of those provisions, one of those exemptions to the policy, you retain copyright. The policy does require you to grant being an active verb, the reuse of your IP to the university, but granting is an active verb. So take steps, if you'd like, to sort of insulate your work and create conversation. And remember, if you are going to reuse material that's been given to you by someone else or encourage someone to reuse material that you're giving them, that license does not cover derivative works. So be careful. You can create some protection. You can create some layers between the learning management platform and your IP for greater control, but student privacy, you have to honor student privacy. FERPA comes first. Don't expose students to risk to protect your IP. And then finally, we can promote a culture of honoring other people's IP, and we can start teaching our students to do the same. Thank you.
Thank you so much, Veronica. I don't know about all of you, but I learned so much, and I'm really excited to do a little dry research in that resource guide. I'm excited to see what's there. And hopefully, I know we're out of time, but if anyone has any further questions or anything, I'm sure that you could reach out to Veronica. Veronica's covered a really big topic for us, but hopefully has generated conversation or will generate conversations and thought as each of us continue to develop our courses and think about how we develop our courses and what our practices are now and moving forward. So thank you so much, Veronica, for everything. This has been really great. And I thank all of you on behalf of the Faculty Development Committee for taking an hour on this Wednesday to be with us.
Well, and I'm going to go ahead and stop the recording here, but I will stick around in case anyone has any questions or wants to discuss any of the contents. Let me go ahead and stop the recording.